Okay. Good evening, everybody. I'd like to thank the AWA+D for inviting us to make this presentation. My part will be very short, but I'm proud to introduce Amy Studeris to everybody. For the few people in this industry who don't know her, Amy has been helping out with projects, leading projects at Pacific Crest for over 5 years and in the industry for 15, 20 years. She is our resident expert at fill in the blank. Amy is our resident expert at subdivisions and at title issues and at deep historic records. So yeah, when most people call and ask how we're doing, if they need help, I say, let me talk to our resident expert, Amy Studeris. So happy to do a very brief introduction about her and what we're going to talk about, and then she'll be doing most of the talking. So what is SB9? The fact that you're here means you probably know exactly what SB9 is, but we thought we would just make it official. It was a state law that took effect January 1, 2022, with the intention of creating more housing in the state of California. The biggest, the elevator pitch, the biggest thing you can tell people with the family get-togethers is SB9 is intended to turn a lot of single-family homes or areas zoned for single-family into multifamily, without overwhelming the neighborhoods as far as size and number of families. The state has some specific requirements for the local cities and counties, saying that they must provide a bare minimum of certain things for this extra housing. But the state did give cities and local and counties the opportunity to modify and to what they do with SB9. Most cities and counties have not had a chance to actually do much of that modification. And so we're talking about right now a state law that's pretty much the same everywhere, but we'll talk about that. Tonight, we're talking primarily about the city of Los Angeles, though. That has been our experience where a lot of people are asking questions, and it is there's a lot of single family residences and zoning in the city of LA. So we're going to be, we wanted everybody to know up front that that's what we're talking about primarily. And so with that, I pass off to Amy.
Great, thank you, Chris. Well, welcome, and hopefully we can go through this, and I'm sure there'll be a lot of questions by the end, and we'll try to be as thorough as possible. There are so many different facets to this, and as Chris mentioned, the various cities and counties, I have been researching on those, and there are variations with each as they've saw fit to adjust it, but we'll focus on our slides here with the city of LA. So what is SB9? So we have noticed with a lot of questions that have come in so far that most people ask us about the urban lot split, which is that second one down below, to subdivide the property. What I think is interesting particularly for this group is that you don't have to go through the urban lot split. You can actually do a 2-unit development. And I don't think that's as widely known as the urban lot split. At least that's the feedback we're getting so far. So if you don't want to go through, or if you have a client that does not want to go through subdividing the property, they want to keep their property as a whole, but they want to add that extra unit, they can go through just through LADBS, the 2-unit development. So we're going to give you both options. The city of LA does break it down, and the county do break it down into both options, and what applies to each. So if you want to go to the next. All right, so the benefits of SB9. The 2-unit development, if we're just looking at that, and by the way, the urban lot split puts it into 2 parcels, and you can do the 2-unit development for each and do it concurrently. So it's either just a 2-unit development or combined. So the 2-unit development, you have the ability to add a second dwelling unit without a planning entitlement case. You can do it by right. LADBS plan check process only. And there are street improvements required. The typical, if you're putting in a new unit, just like if you're adding a single family, working on a single family residence, you will be required to do street improvements. For the, and again, for the benefit there is you can add that before, well, let me back up for this, the single family residential zones, that's where this SB9 applies. And we'll look at that in a second, but in single family residential zones, you can only have one single family dwelling, as you know. This is where the 2-unit development is a benefit for you. You can add that second dwelling unit with a kitchen, and whereas before you couldn't do that. So that is the benefit there. For an urban lot split, it applies to 2 lots. You can only create 2 lots, so it is a parcel map. And as far as City of LA, you would go through the parcel map process. Typically, that would require a public hearing. So, and I'll go to that second point there. The planning fee, the benefit here is that you have reduced fees. The submittal fee is about $4,900, and versus a standard parcel map is going to be approximately $20,000 just for the submittal. And that can depend on the location, if it's in a very high fire zone or not. So that's why we have approximate. So there's a definite savings there. For the urban lot split, street improvements are not required, as a typical parcel map would require them. And that's where we say, you know, when you go through your parcel map and your subdivision, that's where the city gets their pound of flesh. You know, the street improvements, you know, street lights, street trees, widening the street, and dedications. The state law says that street improvements are not required. We'll talk about that later though, because the 2-unit development, if you combine them and have an urban lot split and do the 2-unit development on each lot, resulting lot, there are still street improvements required. So that can be misleading. We have found as we've gone through the memo that you can miss that. So for the urban lot split, if you just subdivide them so you can create 2 lots, you could have your one side of the property and you could sell off the other side and let someone else handle the development and street improvements. So you wouldn't have to handle that. I will say that, you know, some properties, if you have the full street width already and you don't need dedications or street improvements, that might be an ideal property to do that on, so that you're not faced with that down the line when you get your building permit. Let's see. You will have some reduced costs and timing for the urban lot split because it is a ministerial process. That means it's not going to go to the public hearing, and you do not have to do the CEQA. It does not apply here. It's just strictly done through the ministerial process. I will say that for the one time that you will have to do the public hearing regardless is because if it is in a coastal zone. The coastal zone does require a CDP, so you have to do the public hearing no matter what. So if you're not in the coastal zone, you can get past this without a public hearing. And then the CEQA, just another note on that CEQA, you don't have to do all the environmental reports. That's the benefit there as well. On a normal parcel map, you have to go through the CEQA process, depending on the project itself. All right, criteria for qualifying for SB9. The rule is that it's for single family residential zones only. And the City of LA has already created a spot, a link on ZMIS for you to be able to, under the planning and zoning tab, click on that and you scroll down and there's a link for SB9. So that's really helpful if you're looking, you're talking to clients, you can just click on that and see if you're eligible, if that property is eligible for SB9. It'll go through the different categories, and it may say on there, you know, you ask to qualify, but check on the habitat or something. So, and we'll get into that. But that PDF form that you click on, it opens into a PDF. It's a really helpful tool. One of the criteria for qualifying is that you if you get some of these properties that have ownerships that are next to each other, they are not allowed to do SB9 on every single lot next to each other. They're only allowed to do it on one. And I'm, still not sure necessarily how they'll check on that. Maybe they'll have, check on case number, cases next to each other to see who the ownership is. But right now they're saying that adjacent properties can, if they're under the same ownership, you cannot do SB9 on each one. You'd have to do it on one. This, I think, is the sensitive sites that do not qualify are the wetlands, the hazardous waste sites, floodplains, floodways, conservation areas, historic district, if you're an HPOZ. Those are all on that ZEMAS form, and it'll give those check boxes. So if you want to look on there, it will give this area, or it'll say if you need to check further into it. That last one, habitat for protected species, may disqualify it for a site. They are going to ask for bio reports on these projects. And just to, if that's flagged as one of those potential habitat areas, they will require that bio report. So that might be an added expense or time period, figuring out the timing for your project. Let's see. Okay, general provisions of SB9. These are some of the items that they're kind of giving you, similar to like the ADU, where they're giving you some benefits and things you don't have to abide by the typical zoning code. First off is setbacks. None are required for the existing structure or replacement structure in the same location with same dimensions. Here they have stated, we've talked to LADBS, and by the way, we've talked to planning department, met with them, making sure that we've kind of covered everything, as well as LADBS and BOE, seeing how, because this is very new to them as well. And they've had very few submittals so far, and none have been completed. So they're still learning as well. But in talking with LADBS on this setback issue, they're going to want, if you have an existing structure and you want to demo it and put it in the same spot because it's just too dilapidated, it's not in good condition. A lot of times you get to the point where your contractor's out on site doing a significant remodel and they're just telling you, this is not in good condition, I need to demo the whole thing. There's rot, there's different problems here with the structure. This is the provision that allows you to replace an old structure, but you have to put it in the same spot. And you will be granted those reduced setbacks if needed. But keep in mind, they are going to be scrutinizing not just the footprint replacement, but the height and the building envelope. So just keep that in mind if you're looking at a project like that. So similar to the ADU, you are allowed 4-foot side and rear setbacks. Front yard setbacks are going to have to be abided by, but the side and the rear can be 4 feet. So I guess I covered that front yard. As far as parking, you will need 1 off-street parking space per unit. And similar, like I said, to the ADU, they have an exception. So within a half-mile walking distance to high quality transit corridor or a car share drop-off pickup location, you will not have to provide that off-street parking space. They are allowing the space between buildings to not be required, as typically, I think you're required to have 10 feet typically between, as long as both structures meet building code safety standards, they will allow for reduced building separation. So keep in mind here, your existing structure may not meet that code requirement if it's an older structure. So they will allow you to have that reduced setback, but you'll have to keep in mind that existing structure may need to be brought up to code somehow, some way, whether it be the windows, any type of openings, things like that, or the construction type, those are or sprinkling the building. So those are the things that they will still require if you want the reduced setback, building separation. Connected or attached to unit development is permitted. And then as far as unit size, they are guaranteeing that for both units, you can have a minimum of 800 square feet. So if you are over your RFA, they will allow you to have a minimum of 800 square feet. Okay, so specifically looking at the provisions for the 2-unit developments, the unit size, as we mentioned before, it is guaranteed for both units to be a minimum of 800 square feet. You can have larger than that as long as you don't exceed the allowable by right RFA. And then as far as ADUs, they are allowed for 2-unit developments only, not for, if you're doing an urban lot split, this is where they separate it out. You are allowed for, if you're just doing a 2-unit development only, you are allowed to do 2 units plus an ADU. So the ADUs do not count, or JADUs do not count on the 2-unit development only. And as I noted, we noted here below that it won't be allowed on an urban lot split project. So whether you're doing, if an urban lot split project is involved at all, whether you do it on that property or someone did it prior, and you bought one of those resulting lots, you will not be allowed to do an ADU on it or JADU. So potentially you could have 3 units, maybe 4 if you do an ADU and a JADU, if you meet within your RFA. But then again, with the ADUs, they allow you that certain minimum. So, all right, so provisions just for, specifically for urban lot splits. The lot size and area, you can create no more than 2 parcels. Again, it's a parcel map with two parcels. And then when you're configuring the lot, you can't have one be super small and one larger. Each have to be at least a minimum of the 40% of the original lot area. They want to keep them somewhat similar. And you cannot be less than 1,200 square feet. So some of these smaller lots that, you know, in some of these residential zones, just keep in mind that you cannot be less than 1,200 square feet. And you're guaranteed a minimum of 800 square feet. And the dwelling unit count for urban lot splits, you are allowed to have an ADU, but it counts toward your unit count. So you can have your single family residence and your ADU, and then you're done, you're maxed out. Or, you know, alternatively, if you do an urban lot split, and you can create the total of 4, but you'll have 2 resulting parcels. But each resulting parcel is limited to 2 units, no matter what type. So. All right, the dedications and street improvements. So they cannot be imposed as required for a standard parcel map. You still need to create the street access and follow the street access requirements for new residential units. If you are, and they will require, what is a legal lot is 20-foot frontage at the street. And so what they're going to want you to have is a 20, if you're creating a flag lot, let's say, and the other lot, let's say, is at the front. So if you're creating that flag lot, that pole, and then the flag behind, you're typically required to have a 20-foot access strip from the street all the way back for your access. They may allow you to reduce that only if that prevents you from building in minimum of 800 square foot unit. So there will be some flexibility in that only if it prevents you from, or if you have to go around an existing unit that you're keeping. So there'll be some potential flexibility on that, and that would have to be approved by planning. So they will look at the strictness of whether or not you're, number one, meeting that requirement, and further, if it's preventing you from doing your by right 800 square foot unit. So you're not going to get away from the requirement of giving of providing that access strip. So and I say that because I think the example we gave earlier on that little sketch was 2 side-by-side parcels if you're subdividing, and some lots may, based on where the existing house is, you may need to create a flag lot that puts it behind, where you're creating that flag lot. So I just wanted to kind of express that as where the houses are situated, it might be a little tight for you to put that 20-foot strip. So there might be flexibility there based on existing structures. All right, so owner occupancy. This is something that they are going to make the owner sign, whoever is subdividing this property. The standard is that you're supposed to, the owner is supposed to live there for 3 years minimum, and they will sign an affidavit to that effect. They do not specify, it just has to be one of the units. It doesn't, and it can be one that they're creating. But that has to be their primary residence for at least 3 years. And the only way that they seem to be, that as we've talked to them about this, there isn't necessarily a way of them following up on this for 3 years, but the only way I think that would come up would be through code enforcement, where they see that it's not owner occupied. Outside of that, it seems to be not really policed very much. Non-conforming zoning. If there is existing non-conforming rights, they can remain. But if there is anything unpermitted or illegal use or construction, they will be required to be corrected. So anything that's unpermitted, they'll have to deal with. But if there is existing non-conforming rights, they can remain. So for instance, if a structure is already substandard in their side yard setback and it has existing non-conforming rights, then that can remain. All right, so processing back to the 2-unit development. It will, in talking with LADBS, they are going to have the normal plan check process. And as some of you may have heard, you're now allowed to get in-person appointments with Metro. And you can select that and you can submit online now. But it's going to go through the regular plan check process. They're not going to be fast tracking these like some housing development projects, like affordable housing. This is just going to go, they have not indicated that they are going to fast track these whatsoever. It'll be the normal process. And all building code requirements must be met. They're not giving you any extra provisions that you will have to meet those. Regular development fees will apply, such as plan check fee, your developer fee for schools, park fee, linkage fee, and the permit issue fee. Those will all be a part of the permit and normal as usual. Building and safety is encouraging you to meet with your geographic planner if it falls within a specific planning overlay area. So if you see that on ZMIS, when you look on there, if you're in one of those specific overlay areas, they do recommend that you meet with them first. And processes for filing the urban lot split. First, you will submit to planning for the ministerial process. And as we mentioned, the fee is greatly reduced. It's $4,900. It will get assigned to the project planner for that geographic area. And they will be the ones processing the planning case. Once they take that in, much like the typical parcel map, they are going to distribute to the normal departments like BOE, fire, zoning to get their feedback on any conditions that they require. At that time, they would probably let you know if there are any street improvements from BOE. Even though they're not allowed to impose them for this split, but if it is combined with 2-unit development, then you'll be able to find that information out at that time. There is no SEQA, no hearing, unless you're in coastal, remember, and there's no appeal process. So once they issue the determination letter, you're done. They're not allowed to accept any appeals. As mentioned, once they issue the approval, they'll give you a determination letter and any conditions of approval that you will eventually clear when you go to process your final map that gets recorded. And that gets handled through BOE. And more on that to come. You can process the 2-unit development or any building permits at the same time concurrently with the planning case. And by the way, I think this is an error. I did check with them recently, and it is not the PZA process. Some of you may be familiar with that. If you have a housing development, it's the city's way of helping to speed up the plan check process for a housing development project. So if you have a planning case, you first go through, let me clarify, PZA stands for preliminary zoning assessment. So you're allowed to submit to building and safety just for the zoning plan check, and you only pay that third of their plan check fees. And then they give you, plan check it for the zoning requirements, so that when you're going through your planning case, you get your approval and suddenly you have a problem with the zoning issue. And it also helps you kind of speed up that plan check process. Like I said, when we checked with LADBS, they said that they're not processing these through the PZA process. It's just your normal plan check process. So I think we initially had that in there from planning, but LADBS said no on that. So we'll correct that. All right, so as I mentioned earlier, once you get your determination letter for your urban lot split, what you're going to do is have your engineer prepare your final map just as a normal parcel map, because they still need to go through the normal subdivision process where you go through BOE. They do that, you pay their fee for review. They put all the conditions of approval in their system where we have to get the clearances, and then you go, survey division reviews it to make sure all the bearings and distances, all the mapping things for you to go record, that everything lines up and is accurate. So that is all normal process. BOE has said that they are not reducing their fees for SB9. They still have to go through their normal plan check and review process. So for now, that is remaining the same fee. And in fact, I will tell you, when you do your preliminary map for urban lot split that goes through planning, there's a concurrent process there with BOE as well for a preliminary review. And they do have fees for that as well. So again, now we're at the final map process. It goes through their plan check. Any new driveways can be processed as an A permit if it's just for that lot. If they do require further street improvements and you're doing it concurrently with the 2-unit development, depending on what those street improvements are, if they do require dedications and further widening of the street, there is a chance you'd probably have to go through the B permit instead. And that's where the process can take longer and be more expensive. Again, as I mentioned earlier, the conditions of approval are cleared through BOE. And once approved, the final map, which is coordinated through BOE, is recorded with the county recorder as usual. And that is handled by LA County Public Works. So, all right, some housing notes regarding SB9. I've seen a lot of these things pop up lately, so just wanted you to be really aware of some potential problems or just things that you want to look for when you have clients that come to you for potential urban lot split or 2-unit development. This really, I think, is more so an issue with the urban lot split as opposed to just a 2-unit development. I even had someone talked to me recently about a potential site that would be perfect for her. She lived in the back ADU unit. There's 2 units on site. It's zoned single family residential, but there happens to be 2 units on site legally. And she wanted to buy the unit that she lived in back. But the problem with that is that there's 2 units. And if in the city of LA, if you have 2 units, you're automatically subject to the RSO. That is the rent stabilization ordinance. So, so just be careful if your property already has 2 units. There's some things that you want to look into, and I'll get into that in a second here, but I'll just go through my points here. But it says must keep them on the same lot if you're doing an urban lot split. So if you have a property that has 2 units on them already, and you want to do an urban lot split to create that separate lot, you cannot just separate these 2 units because they are subject to the RSO. So, and you cannot LS properties for doing an urban lot split. If you have units that have been LS, that means taking them out of the rental, the rental
Marketplace.
Thank you. There's a process for that LS to remove them from the rental unit marketplace. So if that property has been LS already, you're prohibited from doing an urban lot split for 15 years. So when you're looking at properties, you may want to check in if there's 2 units on it and you're buying it from the property owner is buying it from someone, maybe some past developer or who knows what, and they've already LS the property. That's something you want to be aware of. So bottom line, if you're doing the urban lot split and there's 2 units on there, you have to keep them on the same lot, the resulting lots, and then you can do it. And this is kind of some of these RSO rules. If you have a property that has 1 single family residence on it, it's not subject to the RSO. However, if you add a second unit and that single family residence was built prior to 1978, when you build that new unit is not subject to the RSO, but the single family residence is, because now you have 2 units because it was built prior to 1978. So there's a few tricky things here with RSO. You just want to be really careful. I just spoke, well, I'll go to that third point and then I'll say it further. If there's 2 units, once you put 2 units on a property, if both were built after 1978, they're not subject to the RSO. However, a lot of people don't know that once you have 2 units on a property, you're actually required to register them with housing, because essentially the idea is you're not going to be living in both because you're the property owner. So they don't care if you have a family member staying there, if you're not creating rent, they don't care, but you are technically supposed to register them both with housing. It has to do with them making sure and monitoring that both units are habitable, because they're assuming that not just you're not living in both of them. Someone, whether it's family or not, is going to be living in the other unit. So I learned this recently, and I just, I wanted to talk with the RSO unit just because I feel like there's been a lot of issues that have come up recently on this. And as some of you know, there's a moratorium on LSing a property, and landlords have problems right now removing tenants because of the COVID moratorium, where they've put the moratorium due to COVID. So we don't know when that's going to be lifted. But again, for the urban lot split, you can't LS a property and then do the urban lot split. So just know that there's things that you may want to check with housing if you're not certain. And I was speaking with them, just kind of racking their brain to see, just making sure that I can give you the full information and that you're not caught by surprise. But they've said that, yeah, they've gotten so many calls, particularly with the ADU ordinance, that people didn't realize once they put that second unit on there that they were supposed to register it. And also that given the home share ordinance, and this is one of the things Chris, do we have this on a later slide?
No, actually, I think this is the only place we have it. So
Okay,
with
I
a
will
short
bring that.
answer.
Oh, it's
Yeah,
next. Look at that. It's next.
Yeah.
Short-term rentals.
there it is.
That means 30 days or less. If you have a renter there for 30 days or less, that's a short-term rental. And they had a problem in the city, particularly in Venice, with this and with home sharing and everything. So the bottom line, they're not going to allow short-term rentals on urban lot splits. And I believe also the same thing for the 2-unit developments. Particularly with building and safety, they are going to look at, when you're getting your building permit, they are going to look to see if there's tenants there. So it's going to be LADBS that's policing that part. If it's just a 2-unit development, oh, yep, see, existing tenants right there.
More paperwork.
More paperwork. Just know that if there are tenants on the property, it just means more paperwork. And so there are a lot of just things that you want to look out for on this, and not just assume. I think where the issues come in here are if you've got a single family residence on a property, you think, and you want to add a second unit, people are not going to realize that they're going to have to register with housing. And you want to look at, is it, built prior to 1978 or not? Any new units are not subject to RSO, but anything that was built prior to 1978, they will be. And that can really impact people and what they're planning to do with that second unit. So we just wanted you to be really aware of that, because I don't think that that's known as much. And also the RSO unit, when I was talking with them, they are getting thousands of calls because they thought when they built their ADU that they could, do what they'd like with it and do the Airbnb, and they can't do the Airbnb. So some additional notes. The city council has ordered development departments to develop a city-specific ordinance that may change some of these requirements. For instance, one thing that we did hear from, I think, LADBS is that they may be pulling, you saw at the beginning of the slides, the zones that are required or that are allowed. A1 and A2 was listed on there, and that there was some discussion of pulling that out because it's more of an agricultural zone rather than a single family residential zone. So that may be removed. So if you have a property in that zone, you might want to get it in now.
I would add, Amy, if you don't mind me saying,
please.
Specifically, because this is something that I monitor the city council motions and ordinances. Councilman Koretz specifically said this shouldn't be allowed in CD5's hillside areas, especially streets that are narrower than 20 feet. And so part of the motion to order the development departments to get a city-specific ordinance was to exclude a lot of the hillside areas and a lot of the very high fire safety. So what is that? Anyways, and the state law allows for cities to exempt areas or to remove areas that are potentially fire life safety issues. So I anticipate that when the updated rules come out, it will exclude a lot of the city's hillside neighborhoods.
Yeah, I do agree. I think they're still refining things. They kept warning us, hey, this is new. We've been advised we may be revising things as we go. So just keep looking for any updates on this because I think that we will see some of those changes. And it was highly recommended to us if you are planning on doing if you're going to do any development with the urban lot split and you think you might want to do it down the line, it is really advised that you have those architectural plans submitted as part of that submittal for the urban lot split and not necessarily do them separately, because if you run into the time to get your approval for any reduced setback, like any, let's say building separation, if it needs to be less, if you need to, if your driveway, if your access strip needs to be narrowed, due to an existing building, they really recommend that you get those architectural plans done at the same time, because if you need to request relief from any of those zoning code requirements, that is the time you will do it. Otherwise, you will have to go back. Once you go to building and safety, you will have to go back to get planning approval. You cannot get them approved once after the parcel map records. So you really want to make sure that you utilize the benefit of the existing potentially non-conforming rights allowed by SB9.
So bottom line on that one is we will be happy to tell your clients that they need to hire you because architects are critical even for the urban lot split where you may not be necessarily proposing the houses at the end that you want. All the architects on this call are absolutely necessary for this process.
Absolutely. And we're going to definitely be encouraging that. You're vital to the project.
That's it.
So I think we see some questions here. By the way, I will clarify if you are, I think someone, we'll just go to the top.
Yeah. Okay.
If you're within a ½ mile of public transportation, no parking is required. You're not required to add additional parking if you are within a ½ mile of
a fixed transit stop. Yeah.
Yep, a fixed transit spot.
Yeah. So Danielle, yes, urban lot splits and 2-unit developments are currently allowed in high fire zones, although there's the potential, the biological issues that Amy mentioned. There's the potential that could limit it, but in general, yes, they are currently allowed in high fire zones. But as I just mentioned, we anticipate that when the new rules come out, which wouldn't be for months, several months from now, that'll be one of the areas that they might carve out.
Okay, and then I can do this next one. The minimum lot size, you're required to have a 1,200 square foot lot minimum. But if you're doing an urban lot split, you have to do at minimum 40% of what the current lot is for each parcel. So they do not have a minimum lot width. They are allowing you to reduce that lot width. And you can, another part of that question is you can share a driveway. They will probably make you do a community driveway covenant if that's the case. But I will say you're still required to provide your street frontage. For example, if you can't run them side by side and you need to do a flag lot where you have the strip coming down, you are required you cannot have a landlocked parcel. So the definition of a legal lot is that it has street frontage, even if you do not use that for access. So you may get creative on a property. Maybe it's the steep slope or something on that area and you really can't do access, but you want to use the current driveway shared with the other unit. You will have to, you have to create your frontage, but then you can do that community driveway covenant. I believe the driveway still is required to be 9 feet. Do you know, Chris, the driveway width? I mean, typically they want 20 feet.
Right.
For
yeah,
access.
That wasn't a specific question we asked, but that is, again, like there's a kind of a bottom line theme that a lot of the, especially certainly the building code can be changed. We have to adhere to, and the zoning code. It's when you file for the urban lot split with city planning, then you start having discussions and you start explaining why certain standards can't be met. And I've forgotten the expression, but planning is directed by the state law that a reasonable, not interpretation, but a reasonable determination has to be made. They can't rigidly force us to make every lot exactly like all the other lots, or else the lots would have been split years ago. The flag lot is an urban lot split that's allowed. Most of the illustrations you see are just rectangles because that's easier for people to do quickly. But when you actually start filing, you absolutely can do a flag lot. You can do a lot of creative lots and stuff. And as Amy mentioned, we probably all have worked in hillside areas where you have what's essentially an unusable 20-foot strip to get you to the place where the house is actually going to be. Those are perfectly allowed in the urban lot split, so that's not a problem.
I wouldn't be surprised if a lot of them are created as flag lots, the new lot, because of where simply the existing house is.
Yeah.
Trying to work around that.
What about the 10-foot passageway? So the 10-foot passageway between buildings is not going to be required. So that's one of the zoning concessions that the SB9 gives to homeowners and potential developers of either two home developments or the urban lot split. So yeah, the 10-foot passageway goes away. So does the city require a setback between the 2 units and lots? So the city's actually, they are allowing essentially the same kind of separation as in a small lot subdivision. So there has to be something there to write a legal description that differentiates it, but it doesn't have to be 4 feet or 20 feet or anything like that. Did I say that correctly, Amy?
Yes.
Okay.
I'm sorry, I was trying to read that.
Yeah.
Wanted to make sure I read that right.
Yeah. Does the city require a garage? And is any of the square footage exempt? The city requires parking. Does it require covered parking?
So they haven't been really, they've only addressed as far as how much parking is required for an added unit. So if you have your existing single family residence and then you're adding a second main dwelling unit, they're stating that you don't have to provide that additional parking space unless you're close to that transit spot. So they haven't really spoken much more than that, have they?
No.
Yeah. I think that's it. They're treating it very similarly to the ADU ordinance in that way. Okay. And they're trying to make sure that parking isn't preventing these units from being developed.
So Joanne, to your question, how is the city of LA interpreting SB9 and hillside designated streets? Right now, they are not making a differentiation. They're not differentiating that from the other streets. There are, certain potential, hazardous situations, but in general, the overview here is that hillside SB9s are allowed. But if you ask me if we have the same thing in a year from now, I think we will be saying that they're not allowed anymore. I think that's one of the things that several members of the city council are targeting, because a lot of the residences of those hillside areas do not want 4 homes where 1 home currently is. So I think that's going to be changed. So owner occupancy. So no, here's the thing, you got to live there.
You're signing in. There's a specific form they have in the application that the owner must sign, that they live there as their primary residence. And I have asked them if you need to provide, similarly that I have to do for other planning type of cases, that it's proving the homeowner's tax exemption on your property tax, but they are not requiring us to provide that. But they are requiring that owner to sign that and testify that they live there for 3 years and will for 3 years. So if they don't live there, I mean, you're required to. So the idea here, I think, is the owner is going to occupy one of these units. So if you're planning on doing an urban lot split and you're not going to develop, let's say you sell off the other side and let someone else develop that, that's when that developer will pay those linkage fees on that lot. But on the lot that they're remaining on, if they develop a second unit, they would have, on that second unit, have to pay the linkage fees. They're not removing that requirement because the assumption is that they're living in the other unit.
Thank you. I hate the linkage fee questions. Is the city planning to include R2 to the urban lot split? Right now, the city's departments have been instructed to exclude areas, not to include new areas. And the R2 zone, to be fair, is currently a 2-unit zone. So, you know, if there was people writing in letters, talking to the council members, talking about the benefit of doing R2, I do think that there wouldn't be much, you know, neighborhood opposition like you see in the hillside areas. But right now, the motions that were made, and in talking with people in planning, which is the ones who are dealing with the zoning issue, I have no indication that they're going to add any zones to this process. Okay, would an alley count as frontage for an urban lot split? No.
I don't think it would either, because the assumption is that they, how many times do we see properties that have alley without the front, the other
Right.
street?
Alley access definitely, but I don't think you'd be able to do frontage. I think here's where you'd have to have that, you know, the unusable frontage to the actual street, and then easements to provide access the potential lots if necessary.
I think that boils down to what the legal lot definition is. And when you look in the definitions, if it just says from a public street or private street, I don't believe that it lists alley. If for some reason it lists alley there, then you'd be able to, but I don't believe that it does.
Okay, I agree with you.
Okay.
So yeah, you really need to get that 20-foot frontage for the second lot. You can't put it in the back is the bottom line.
Okay. And let's see, interior lot.
So I think we just asked for a second question. To Charles, to your question, can we submit to planning for approval of a lot split only and then submit plans? You can. Building and Safety doesn't recommend it, and we wouldn't recommend it to Pacific Crest, because part of the lot split review, it would be beneficial to have architectural plans with that lot split documentation. So, but you can officially, you can.
If you have a type of lot that you are fully confident that you can meet all the zoning code requirements with, outside of, you're allowed to have 4-foot side yard and rear yard,
yeah,
then you know, if you can abide by the requirements for SB9, then, and you're confident with that, then I would say fine. But they strongly recommend, as we've seen many projects go through in general, when suddenly you need entitlement for a reduction, you have to go through that process with planning. But and it's better to get it all taken care of at once.
So there's an RSO question, Amy, so have at it.
Hey. He's so happy he doesn't have to do it.
I was on, for the record, I was on the planning call and the building and safety call. When Amy said she scheduled the housing call, I was like, good job, Amy. I did not volunteer to be on that call.
Yeah, a lot of housing is hard to get a hold of, especially with COVID, because they just do emails right now. So they're an interesting group. Okay, a second unit such as a detached ADU has to be registered for RSO. No, I would say it this way. Any new unit is not subject to RSO. But what the clarification is that you need to register with housing if you have 2 units on a property, and you're not subject to RSO, the rent stabilization ordinance, but you are subject to them just registering that you have 2 units on the site for I think they call it the SPEC which is, I don't know the acronym, I should have looked that up ahead of time. But basically you pay a very minimal fee every year to be registered with housing. So you're not subject to RSO, but you are registered with housing because they need to make sure that they are habitable. So, but the fact, so again, you're not subject to having to have a certain rental requirement, because you are allowed to just have family member there or your nephew live there while they go to UCLA or USC. I don't know how many people went to USC, but I always think of that because of Mello, because it's on the coast. So, yeah, so it's not that you're subject to a certain reduced rental rate. It's just that you have to register because you have 2 units. I hope that clarifies it.
Makes sense to me.
Okay.
Akeem asked if we can have the slides emailed to us. So I know that AWA+D is going to post this on their YouTube, and we did this presentation for AWA+D, so we will follow their lead on how to be distributed. So Sarah can tell us later.
Okay. Yeah, if you feel like you'd like to share the file, that's perfectly great. Otherwise, I think this is going to be probably even more helpful to have on our YouTube page, really, because you've elaborated. So if you sent us the file, we'll distribute it.
Okay, great. Sounds good. So I think that Amy just answered for that RSO part really kind of hit a nerve, Amy. You,
I knew it would.
Yeah. So yeah, not registered for RSO, but registered with the housing department as a rental unit for part of their tracking and monitoring. Yeah. Okay. What if the owner lives in the house built pre-requirements and rents out ADU? Do we have to register the original house? So this, Amy, you can explain this better, please.
This boils down to if the original house was built prior to 1978. And I think, it's difficult because on a single family residential property, you have your one main dwelling, and then suddenly you're taking advantage of SB9. This is where they're kind of getting people, and I don't think they're going to realize it. So if it was built prior to 1978, and now you suddenly add that second unit, whether it be an ADU or another main unit provided by SB9, then that original single family residence will be subject to RSO. The new unit will not, because it was built after 1978, but that new unit will be. And I think that's where the difficulty comes in.
Okay, but that sounded good to me. So on development mode, they're only allowing 2 units plus 1 ADU. Is that correct? Yes, we triple check that before this, this in fact. So yeah, it's kind of ironic, but you could actually get 3 units out of 1 lot, or you could suggest to your clients 3 units out of 1 lot rather than doing the lot split and ending up with 4. Because you could do a 2-unit development and you still are eligible for an ADU. So that's if you don't do the urban lot split. All houses have to meet building code and most of the zoning code requirements. But if you're trying to maximize the amount of dwelling units, then you can get 3 on 1 lot or 4 on 2.
And I think that, I think it's hard to say, but I do think that most properties are going to be potential, depending on how much they want to max it out. I think that there's a lot of room for the 2-unit development only, where some people may not want to deal at all with the urban lot split and just maximize your units, get 2 units on there and an ADU. That way you can have the 3. It seems like that might be the easier route for some of these smaller lots that aren't so large. But again, there's going to be, I think, people out there, developers, that will see it and go, we can maximize it, do the urban lot split and do that. But the nice thing there, I think, with that provision, with just the 2-unit development only, and it has never had the urban lot split, you can get the 3 units.
Yeah, especially if you have clients who who you know are just heard, oh, I can get more units here, but you know that they don't have, you know, the developers' deep pockets. We can get a second house, at least 800 square feet, and then also an ADU as well. So that might be a way to guide, and especially I think for me this really crystallized when we talked to building and safety, and they said, oh heck no, we're going to treat you just like any other development. You get no shortcuts with us. And then we realized that also meant in terms of street improvements that tied to the lot split, BOE is going to take their pound of flesh. So it's not, the lot split is not as simple as the headlines would suggest.
Exactly.
So Ruben, I think we answered your question, but just to be clear, a 2-unit development can be single family dwelling plus an ADU, or it could be, you know, what you can currently do, a single family dwelling with an ADU. But you don't need anything special for that. Okay, so if you remove, so you have to replace the parking if it's removed, if you remove the garage for the second unit, or is it like the ADU law?
We didn't cover removing parking.
Please hold. Yeah, so it's, you don't have to add extra parking if you're putting in the units like the ADU rule, if you're within the half mile of the transit. But if you remove the garage for the second unit, so you're without parking. Honestly, I don't remember the answer to that one.
They really only deal with parking required for adding a second unit. So I don't think that it may be the same as I think at that point, you just want to take care of the ADU ordinance and convert that garage into an ADU because they allow that provision. In here, they're not seeming to speak to converting a garage to a second unit. But that is actually a very good question. I think I will double check while we're going through maybe the others.
We'll have to get back to that one.
Yes.
Okay, Astra, the 20-foot frontage is required for both units, not just one, not just the new one. So I can answer that quickly. Does the city require a deed restriction as to the owner occupancy? Absolutely. How can they enforce it? I mean, to be honest, there's a lot of stuff that we file covenant agreements for our clients, and sometimes our clients are worried about landscape requirements in the Mulholland corridor, for example, and we tell them this is the requirement. I have yet to meet an inspector who is looking around saying that's the wrong kind of grass and finding people. They do not have any new financial mechanism for getting more city inspectors to enforce the owner occupancy. So based upon what the city has done in the past, they are going to tell you, and they're going to force the owners to file a covenant and promise that they will live in one of the units that is created. But the only way it's going to get triggered is if the neighbor next door hates them, and the neighbor next door complains and says they've only got renters and there's no. And then at some point down the line, an inspector would cite them, and then they have to fix the situation. If they don't, then at some point down the line, it's possible that they could get dragged in front of the Board of Building and Safety Commissioners, and permits can be revoked. Nuisances can be cited, et cetera, et cetera. But I mean, to be completely honest, they're not hiring a bunch of new inspectors to take care of this. Okay, and then Sarah answered.
So I did want to say for the urban lot split, they're just requiring that owner occupancy on the declaration. So, and they're not requiring, I don't believe that they're requiring something to be recorded, much like the ADU.
Okay.
So it was really, because we really questioned planning on this and said, do we need to provide proof of this? They just have to sign this declaration. As far as building and safety, they just are really looking for tenants if there's existing.
So is it possible that when we get into a lot split approved, though, that part of one of the conditions could be the recording of a covenant agreement that includes these conditions,
Yes.
which would be the ownership question.
And that's where I think they're going to start developing their process, because much like our other determination letters, we always record a covenant agreement to abide by the conditions of approval. So part of that is that they're probably going to have in there that it's owner occupied.
Sure.
And so to that effect, yes, I think they will have to record sign and notarize and record a covenant for that.
By the way, Amy mentioned this earlier, and I do want to stress this. First one in, you're going to be first one approved, because we're still, there's been, even 5 months later, since the law took effect, there have been, I believe we found out 3 urban lot splits that have been filed, none
Yes.
close to approval. All of those were filed within the last couple of weeks. And Building and Safety told us 2 weeks ago that there were 11 lots.
19.
I'm sorry?
19.
11, 19,
Somewhere in there.
Auto.
Oh, yeah.
Yeah.
Maybe it was.
Yeah. So this is all still brand new. It's traditionally Pacific Crest, we look at previous examples and help us guide us forward, but there is no previous examples. So that is also one of the reasons why we're saying, good question, we should look into that, because building and safety and or planning haven't gotten to that point yet in approving projects.
I'd just like to interrupt for just 1 second.
Yes,
I know
sir.
these questions keep coming in, and I appreciate everybody's interest, but we can't stay here all night, and I know this is just out of respect for everyone here. I want to make sure that we end this at a reasonable time. So if you guys just take a couple more questions, I don't think we should add any more to the end, but I can put contact information for everybody on here for your follow-up questions if you need. So. A couple
Great.
more questions. Thanks, Amy.
Okay.
Yeah, I do want to clarify. Astra had that question on the street frontage for both units for a 2-unit development. You have a legal lot there, so you have your 20 feet frontage. So you're not required to have 20 feet frontage for just a 2-unit development. That's one property. So I wanted to clarify that that 20-foot frontage is if you're splitting it with an urban lot split, and you need to create a legal lot with 20-foot frontage. So I really wanted to clarify that, because that's important with a big differentiation.
Thank you. Andre, thank you for acknowledging that we just answered that question as you're typing it. So I'm going to keep going. Okay.
Thank you.
Is there any particular questions that we should jump into that we haven't? Okay, Michael Marsh, the fee for, the urban lot split is the planning fee. The fee for the 2-unit development, goes straight to building safety, and that's every fee that you're used to doing for, permitting. So
Yep.
There's no savings there. The state did not promise or force cities to save money for applicants. They just said, do this. And so the city is taking full advantage of being able to charge every fee. And so Danielle, yes, the 2-unit development can be attached. Charles, County of LA, there's a lot of overlap. There are a couple of differences, but as you could see, we knew that a presentation just of the city of LA would take a lot of time and be very popular. So we didn't have time to differentiate with the County of LA. Amy, is there any big themes you want to talk about?
There's not really anything. They do not allow coastal, period. But as far as the rules otherwise, they're very similar. The same 1,200 square foot minimum lot size, 40% minimum of the original lot. They really follow the same. It's all the state guidelines. So far from what I'm seeing from the county, it is falling in line.
To Elaine and S. Paddock, I think just to be clear and try to draw the line, and maybe this will be it because the themes are kind of coming out, Sarah. But so if it's the 2-unit development where it's 1 lot, 2 units, you don't have to sign the agreement that one of those units is going to be owner occupied for 3 years. That's a development. Please correct me if I'm wrong, Amy, before I get too far along. But right, if you have a single family dwelling and you're going to add another dwelling unit to that lot, you can go ahead and sell that singular lot. It's when you do the urban lot split that you suddenly have that the city is going to require the developer to promise that they're going to live there for 3 years.
Okay, so just to clarify, if you're just doing a 2-unit development, you cannot sell your second unit. It's on your property.
Yes.
I think maybe you said that. So the 2-unit development is keeping it on one property. You can rent out the second unit, but you can't sell it off because you don't have a separate parcel now. That's what the urban lot split is for, is to divide the property up so you can develop it and sell it off if you would like. So if it's 2-unit development, you can rent it out, but it's on your property. You can't sell it because you don't have a separate parcel to sell off. Does that make sense to you, Chris? Anybody that can respond?
I'm allowed to say yes.
Because the way I'm reading that question, Elaine, I just wanted to clarify that.
It was really about developers. Are they going to be able to sell the properties? That's kind of
Right.
what I was getting at.
Well,
Yeah.
we've had a few developers contact us and say, I want to do the 4-unit split. And I said, great, are you going to live in one of those units? Because if not, you can't do it.
And I will say that
Exactly.
yeah, and the application is kind of funny right now, and I think they're going to revise it, but I think it words it as applicant or owner. And I think I saw planning's eyes get really big and say, oh, well, it can't just be the applicant, it's got to be an owner. So I think they didn't word that right. So just keep in mind, there needs to be one of the units needs to be owner occupied.
If you're doing
But that will have to be the 2 years if it's doing just the 2 units on one property.
3
To
years.
develop it, they 3 years, but for one property. So that means the developer won't be able to buy a property, develop two buildings on it, 2 units on it, then sell it, as the developers tend to do.
Just for the 2-unit. That 3-year was really just for the urban lot split, I believe, Chris.
right. Yeah, that's the distinction I'm trying to make, and I'm not saying it very well. If you do the urban lot split,
Okay.
that's what triggers the ownership 3 years. You're, really, no developer's really going to be interested unless they're going to take the chance that they're going to get caught that they don't live there with the urban lot.
Exactly. So no developers will do the urban lot.
No, but yeah, no,
If
no
they
developers
legally
will
want to do it.
legally, right? But if a developer could absolutely buy a house, a lot with a single family house, build the second house, and then the third ADU, and sell that whole package. Can't
Okay.
sell off the different pieces, but they absolutely, because there's not going to be a requirement to live in any of those 3 houses or dwelling units, I should say.
Okay.
So
There-
that a
you.
developer could do.
Yeah, for those 2-unit developments, they're really concerned about any tenants that are there.
Oh yeah.
And if there's an existing tenant, I don't think I noticed this earlier. If there is an existing tenant, they're going to be looking to make sure that if you're building a new unit on the site, if it's far away from that existing unit, then they'll be fine. But if it's really close, they want to protect, the noise and the comfort level of that existing tenant. So they may be looking at that, just a heads up. And that's strictly LADBS.
Okay, Sarah, stop us before we keep going.
There's a limited amount, but these do stop at some point. But we can quit anytime. I really appreciate all these questions you're answering.
Okay, well, we should read Annie Chu. Highest recommendation, just hire. Thank you, Annie.
Okay.
Yeah, and I think it has been about 20 years. Thank you for that. Can we promise a follow-up in 30 days as to how the process is going? I will say that we produce Pacific Crest. We produce a newsletter, an email newsletter that we send out sporadically. But it's gotten more and more frequent, especially as big issues like this. It's meant for professionals in the industry. It's not for our homeowner clients. We don't send it to them. And so I have since last roughly October, I've probably sent about 5 updates about SB9. And I've gotten 2 people who canceled their subscription because they said there was too much. But everybody else still seems to be happy with it. So when Sarah gives you our contact information, if you email me and say you want to be added to the list, I'd be happy to put you on the on that distribution list. And we will be updating all the professionals we work with as this process goes forward.
Well, thank you both very much. Thank you, Amy, for presenting. This has been really helpful and enlightening. And I don't know, we also appreciate all of you. We've had a lot of people here tonight. So I know there's a lot of interest in this topic, and I'm just so thankful that you guys have gotten the latest anyway, and have stayed on top of that enough to share. So we appreciate you. And you guys will send me your PowerPoint and I will share it. And okay. I will also share links with that. And we hope you all have a great night.
You promised us their emails.
I will have their email address and their website. Yes.
Thank you, Sarah, very much for inviting us. It's been, I got to say, we've really enjoyed being part of this organization and love celebrating 100 years. This is phenomenal, and love helping spread information and knowledge. So thank you very much for having us.
Yes, thank you so much.
Have a good night, everybody.
Thank you.
Thanks for answering our questions.
Sure.
Thank you.
Welcome.